Good morning and welcome to another episode of Rock the Closing. Today we are going to be discussing the contract deposit. Very important. First exchange of money. Very exciting step in the process. So, Orsolya, tell us, what is a contract deposit?
Good morning, Dalia. So the contract deposit is an initial deposit of money given by the buyer to the seller when the contract is signed. It is also referred to as earnest money. Okay? How much is it, Dalia? Let's start with the most important question. How much does the buyer has to give to the seller in terms of contract deposit?
Good question. A lot of people think that this number is up to them or it varies, but in reality, in New York, it is a standard 10%. 99 times out of 100 deals in New York City and in other parts of the country, in other parts of New York too, it's always 10%. Outside of the state, it can vary, but we're just talking about New York here. I have seen some exceptional cases where 1% was given or seller requires up to 20%, 25%, 30% even. So there are some special circumstances, but you'll know that probably right off the bat before you even sign the contract, before you even get into a deal sheet, if somebody's requiring more than 10%, because that's something you definitely need to know. So yeah, we're looking at 10% really. Orsolya, why don't you tell us, what is the purpose of this deposit?
So the purpose of the deposit is to show on behalf of the buyer how serious he is and to secure his interest in the property. And the security takes place through the deposit, and the deposit secures the interest throughout the entire sales process, and it shows the commitment of the buyer to the seller. So yeah, we will go into in a few minutes how this seriousness is taken and what is it translates to. But let's talk about something that is often not clear to the buyers, and I find myself to explain usually is, when is this deposit given?
Yeah, good question. So when it's given is at the contract signing. So we probably discussed it in an earlier episode. The seller provides the contract, and once the contract's agreed upon, the purchaser is the first one to sign the contract. So upon signing the purchase agreement, the buyer will provide the seller with the 10% deposit. Okay. At that point, the seller will receive the deposit, and only then will they sign the contract. So they really need to see the check, get the wire, whatever the case is, to know that the buyer is serious. And then the seller will sign the agreement. Okay. So, Orsolya, why don't you tell us, how is the deposit typically provided to the seller?
Right. I think you went into a little bit into that, but I'm going to give you a little bit of more explanation. So the deposit can be given usually in two different ways. One is a wire to the seller's representative, to the seller's attorney's escrow or IOTA account, which is a special attorney account where deposits are held. And so it can be via wire. That's one way to do it. Usually that's the fastest way to give a deposit. The other option would be to give a check. So the buyer gives a check again to the seller's representative, to the seller's attorney, who deposits it again to his escrow account, which is a special attorney account. And when the check clears, when the wire hits and clears on the attorney's account, is the moment for the seller to countersign the contract. Now step back. There are two issues. So as long as the wire has not arrived on the seller's attorney's account, the seller is not going to countersign the contract. As long as the check has not cleared on the seller's attorney's account, the seller is not countersigning the contract. This is very important. Check can bounce. If the check bounces, then there might be some penalties in the contract that the buyer has to pay in addition to replacing the check. And also, if it's a check, it can take up to 5 days. So be aware, as long as the seller is not countersigning the contract, anything can happen. Okay?
Good point. Especially with these large check amounts, sometimes it does take longer to clear. It's not a, $25 check that clears the next morning. So we definitely have to be aware of that.
Correct. Exactly. It takes often 5 days unless it's a certified bank checks. Those are usually clearing faster. But if it's just a personal check, which I have seen quite a few times, it takes 5 days to clear. Anyway, it depends on the bank. It depends a lot, but this is something to be considered. Dalia, we are talking that this contract deposit goes to the seller's attorney's IOLTA or escrow account. But when is the seller actually receiving this deposit?
Okay, so a lot of my buyers have this concern that the seller is going to run off with their $60,000 contract deposit, and who's to say that they're going to sign the contract or what have you, right? So we do have some balances in place. Like you said, the check goes to the seller's attorney. It goes to the IOLTA account. This is, an attorney trust account. This is, held in trust. Okay, so that's not going to the seller. You're never going to be writing a check to the owner of the property for your contract deposit. The seller actually receives it at closing, along with everything else, the remaining balance from the mortgage, the cash proceeds, any other closing costs, all those checks that get exchanged at the closing table. This contract deposit is going to be written from the seller's attorney to the seller at the closing table. So that's when they receive it. So there's no danger of the seller's attorney just handing over that deposit to the seller at any point before you see that check cross the table at the closing. Okay, so that's something that I see a lot of buyers are concerned about. And it's a valid concern if you don't really understand the process. And that's a large amount. So you have to have your concerns. Orsolya, why don't you tell us, is there any situation when the deposit is returned to the buyer?
Right. So let's just start with what we have been talking about, clearing the check and so on. So for example, one consideration for the buyer is that, for example, he wired or his check has cleared on the seller's attorney's account, and then the seller is simply not countersigning the contract. If the seller is not countersigning within a day or two, I would start representing a buyer, I would start to be a little bit nervous and say, yeah, what is the holdup? So I would start asking the question. If after 5 days the seller still hasn't countersigned, then I would say that we are getting close to the point that the buyer, within reasonable time, has a legit reason to demand the deposit back. This rarely happens, but there are in circumstances. Other cases when the buyer can get legally his money back is when the contract is based on a contingency clause, for example. The most obvious one is that contingency clause is that the buyer has to take out the mortgage, and for some reason the bank refuses to provide a mortgage. In this case, the contract deposit goes back. Another contingency clause is that the buyer is purchasing a co-op apartment and it's contingent upon the board approval. For some reason, some co-ops in New York City, they may still refuse buyers. And if that happens, then the seller and the seller's attorney is obligated legally, because it's a contingency clause, to give back the contract deposit to the buyer. Another contingency could be that the parties entered into a contract. The buyer is saying, I want to buy your property, but in order to do so, I am contingent on selling my home that I own currently. It might be that the buyer's home sale is not going through. In that case, again, this was a contingency clause that it didn't go through. There are some other circumstances. I don't want to go into detail, but this may come up, which would be like the seller's death, the seller's incapacity, the seller entering a contract under duress. this would be cause for litigations, but we don't want to go down that pathway. So I will stop here and rather would be interested, since you asked me the question when the buyer gets back the deposit, I want to ask you, Dalia, is there any scenario when the seller can keep the deposit without closing on the deal, on the contract?
Yes. So this would be a very unlikely scenario, but it does happen. And it's not ideal. There's something definitely going wrong if the seller is keeping the deposit and we're not closing on the contract. So as the buyer, this is something that you need to be very aware of because you definitely don't want to lose your deposit. So a circumstance in which a deposit would be kept by the seller or basically released to the seller by the seller's attorney would be if the buyer breaches the contract without a valid reason. So you'll see in the contract, there are all these contingencies, like you said, valid reasons for the buyer to get back their deposit. But if they breach the contract, if they don't comply with all the terms in there, then the seller will be entitled to keep that deposit. If the buyer is violating timelines, there's going to be timelines in the contract. If they're violating these timelines for no reason, if they're not submitting their bank loan application, that would be considered willful violation of the contract. If they're not cooperating in the loan process, the bank is asking them for documentation and they're just kind of refusing to go along with the process, that's going to be an issue. So the contingency in a contract that, this contract is contingent on the buyer obtaining a mortgage, you can't just get out of contract by not applying for the loan anymore or refusing to submit paperwork because that's not going to get you out of it. You really have to show that you tried to get that loan. So if you change your mind after the contract signed, it's not a good idea because the seller is going to be able to keep your deposit. And it's pretty easy to prove that, you did or did not comply with the loan process because emails are flying back and forth from the loan officer. So everybody knows what's going on. Another reason that the seller might keep the buyer's deposit if the buyer fails to submit the board package. So like you mentioned, there's a board application, there's a board package, just like any other application. All this information has to be filled out, agreed to, maybe an interview. You have to go along and do all that. That's part of it. And if you fail to submit that, they may be entitled to keep your deposit. All right. One other reason that the seller might keep it is if you have a contract that is not contingent on obtaining a mortgage. So in a situation where you are buying all cash, you are bound to buy that property. You are bound by that contract, regardless of whether or not you get a mortgage. So this is kind of risky to do. So you have to be sure. But if you're buying all cash, have the money. Because if the closing comes up and you don't come up with the money, it is a breach of contract. So they will be able to keep your deposit there as well. So definitely things to be aware of. But if you follow the process, you should be fine. If you, stay in contact with your agent and your attorney about timelines and processes and just do everything you're supposed to do as the buyer, then this should not be an issue for you. All right. So what else, Orsolya?
That's pretty much it. That concludes. And I just want to emphasize what Dalia said in her last sentence. We are not here to talk and to give legal advice. We advise you to turn to your attorney and work with your attorney in this entire process, because this podcast, Rock the Closing, is just an information channel. And I thought that it's a good moment to remind all our listeners once again that we're just providing some information, some explanation, how the transaction processes are carried out in New York State. Thank you so much for listening, and we are looking forward to having you at our next Rock the Closing. Bye.
Thank you. Bye. Thank you for tuning in to Rock the Closing. This podcast is hosted by real estate attorneys who offer valuable insights. Please remember that the content is for educational purposes only and does not constitute legal advice. Always consult a qualified professional before making any decisions. This podcast is copyrighted by Rock the Closing, and any reproduction, syndication, or rebroadcasting of the content requires written permission.